Before we dive into one of the most exclusive clubs in the world, please remember, this video is for informational and entertainment purposes only. It does not constitute legal advice, and watching it does not create an attorney-client relationship. For any legal issues, you should always consult with a qualified professional licensed in your jurisdiction. Now picture a lawyer in a courtroom, a packed gallery, a nervous client, a jury hanging on every single word. He's pacing, he's passionate, he's pointing a finger at a witness on the stand. He shouts, "Objection!" He pulls out a surprise piece of evidence at the last second that blows the case wide open. It's high drama. It's what we see in movies and on TV. It's what we think a great lawyer is. And that lawyer would be absolutely, utterly destroyed in front of the United States Supreme Court. They wouldn't just lose their case. They would be fundamentally unprepared for the game being played. Because the truth is, there are two different universes of law in America. In one universe, you have the more than 1 million lawyers you might encounter in your daily life. And in the other, you have a tiny, elite, almost mythical group of specialists who operate on a completely different intellectual plane. These are the Supreme Court advocates. And understanding the vast chasm that separates them from everyone else isn't just a piece of legal trivia. It's the key to understanding how the most powerful and consequential decisions in the United States are actually made. It's about seeing behind the marble columns and the black robes to the raw mechanics of power and persuasion that shape your rights, your business, and your future. So what is the secret? What makes this handful of lawyers so different? It's not just that they're smarter or that they went to better schools, though that's often part of it. It's that they have mastered a completely different set of skills. They speak a different language. They think in a different way. Over the next few minutes, we're going to dissect this elite species of lawyer. We're going to break down exactly what separates the lawyer who argues about your speeding ticket from the one who argues about the fate of the nation. And by the end, you'll see the American legal system in a whole new light. To understand the extraordinary, we first have to define the ordinary. So let's talk about the regular lawyer. This is the person you hire for a divorce, to draft a will, to sue your neighbor over a fallen tree, or to defend you in a criminal case. They are the backbone of the legal system, working in the trenches of state and local courts. Their world is one of facts, evidence, and people. Their day is a whirlwind of client meetings, frantic phone calls, and mountains of paperwork called motions and discovery requests. They spend countless hours in depositions, which are out-of-court Q&A sessions where they question witnesses under oath to figure out what they know. The pinnacle of their craft is the trial. Here, the regular lawyer is a storyteller, a performer, and a psychologist. Their audience isn't a panel of 9 legal scholars. It's a jury of 12 ordinary citizens. Their job is to weave a compelling narrative from a messy collection of facts, emails, and witness testimonies. They have to be masters of rhetoric. They need to know how to connect with a jury on an emotional level, how to make them like their client and dislike the other side. They have to be experts at cross-examination, thinking on their feet to poke holes in a witness's story, to catch them in a lie, to expose their bias. The entire performance is aimed at answering one fundamental question. What happened? Was the driver negligent? Did the company breach the contract? Did the defendant commit the crime? The focus is almost entirely on establishing the factual record. Who did what to whom and when? These lawyers are masters of their local domain. They know the specific judges, the quirks of the local court rules, and the temperament of the community they practice in. They are street fighters, and in their arena, they are formidable. But the moment a case is over and one side decides to appeal, the entire universe shifts. The case leaves the world of the trial lawyer and enters the world of the appellate lawyer. And this is the first and perhaps most important distinction. A Supreme Court lawyer is first and foremost an appellate lawyer of the highest order. They don't operate in the world of what happened. They operate in the world of, was the law applied correctly? Think of it this way. A trial is like filming a movie. You have actors, witnesses, a script, the facts, and a director, the trial lawyer, trying to create a compelling story for an audience, the jury. The final cut of that movie is the trial court's decision. An appeal is like being a film critic. The appellate lawyer doesn't get to reshoot the movie. They can't introduce new evidence or call new witnesses. The story is set in stone. Their job is to watch that movie frame by frame and argue that the director, the trial judge, made a critical error in how the movie was made. They aren't arguing the facts anymore. They are arguing the law. They're saying the judge misinterpreted a statute, or misapplied a previous court ruling, or violated a constitutional procedure. This is a monumental shift in thinking. The skills that make a great trial lawyer, charisma, emotional appeals, the ability to charm a jury, are suddenly worthless. In fact, they can be a liability. The audience is no longer 12 regular people. It's a panel of brilliant, highly skeptical, life-tenured judges who have read everything and are looking for one thing only: a purely intellectual, logical, and legally sound reason to overturn the decision below. There are no surprise witnesses. There is no aha moment with a hidden document. There is only the cold, hard logic of the law. The battle is not fought with fiery speeches in a packed courtroom, but with dense academic legal briefs that can be hundreds of pages long, filled with citations to obscure cases from a century ago. It is a battle of intellects, a high-stakes chess match where every word, every comma matters. And the Supreme Court is the final grandmaster level of this chess match. A regular appellate lawyer might argue about the interpretation of a state regulation or a specific contract clause. A Supreme Court lawyer is arguing about the very fabric of the Constitution. They aren't just arguing about what the law is. They are often arguing about what the law should be. Their arguments have the potential to affect every single person in the country. The pressure is immense, and the intellectual firepower required is off the charts. They are not just lawyers. They are legal scholars, historians, and philosophers, all rolled into one. And they must present their entire universe-altering argument in a terrifyingly short amount of time. So, if it's not about dramatic speeches and surprise evidence, what exactly happens in that one brutally intense 30-minute window of oral argument that can change American law forever? It's a performance unlike any other in the legal world. And the journey to get there is even more remarkable. Forget everything you think you know about becoming a lawyer. Erase the image from your mind of a scrappy student at a local night school, poring over books, who then hangs a shingle and starts taking on clients. That path, while noble and the reality for hundreds of thousands of attorneys across America, has almost nothing in common with the road to the lectern at the Supreme Court. The journey to become a member of this tiny elite club is less a career path and more of a meticulously curated pipeline. A gauntlet designed to filter out everyone but a very specific type of legal gladiator. It almost always begins at one of a handful of law schools. We're talking about the Harvards, the Yales, the Stanfords of the world. These institutions are the de facto recruiting grounds. But just getting a degree from one of them isn't enough. Not even close. The next and arguably most critical step is securing a federal appellate clerkship. A clerkship is essentially a 1- or 2-year apprenticeship with a powerful judge. While your average law school graduate is learning how to file motions in a county court, a federal clerk is sitting at the right hand of a judge, helping them decide the most complex and important cases in the nation. They are inside the room where it happens, drafting opinions, debating legal theory, and gaining an unparalleled insight into the judicial mind. But even among these prestigious clerkships, there is a holy grail. A clerkship for a justice of the Supreme Court of the United States. This is the legal world's equivalent of a golden ticket to Willy Wonka's factory. The competition is beyond fierce. Each year, the 9 justices hire a total of about 36 clerks. They are chosen from a pool of thousands of the most brilliant young legal minds in the entire country, valedictorians, editors of the most prestigious law journals, and graduates with flawless academic records. Landing one of these spots is a signal to the entire legal profession that you are, without exaggeration, one of the smartest lawyers of your generation. These former Supreme Court clerks form an elite fraternity known as the Clerkerati. They have spent a year learning exactly how the court works from the inside. They know how their justice thinks, how they persuade their colleagues, what arguments they find compelling, and what questions they are likely to ask. They've seen how the sausage gets made. This experience is invaluable, and it becomes the foundation upon which a Supreme Court practice is built. It's like learning to play chess by being mentored for a year by Magnus Carlsen. You don't just learn the rules. You learn the strategy, the psychology, the very soul of the game at its highest level. After this finishing school, the path often leads to one of 2 places. The first, and most revered, is the office of the Solicitor General of the United States. The Solicitor General, often called the 10th Justice, is the lawyer who represents the federal government before the Supreme Court. The team of elite attorneys working in that office lives and breathes Supreme Court advocacy. While a typical lawyer might hope to argue just one case before the court in their entire lifetime, lawyers in the SG's office might argue several cases per year. It is the ultimate boot camp. The standards are impossibly high. Every single brief is scrutinized. Every argument is pressure tested in brutal practice sessions called moot courts. where colleagues and former SGs play the part of the justices and tear the argument to shreds to find its weaknesses. Working in the Solicitor General's office is like being a fighter pilot at Top Gun. You are constantly training, constantly flying missions, and constantly being pushed to the absolute limit of your abilities, surrounded only by the best of the best. This is where many of the most legendary Supreme Court advocates, from Chief Justice John Roberts to Justice Elena Kagan, earn their stripes. They develop an intimate familiarity with the court's rhythms and the justices' personalities. They learn to speak the court's language. The other primary path runs through the private sector, but not just any law firm. We're talking about a small number of powerhouse firms, mostly based in Washington, D.C., that have dedicated Supreme Court and appellate practice groups. These are the legal world's special forces. Companies, organizations, and even states will pay these firms millions of dollars not to handle their initial trial, but to be brought in at the very end when a case is on appeal and has a prayer of reaching the Supreme Court. Their job is surgical. They take a messy, complicated case with thousands of pages of records and distill it down to a single pure, compelling legal question that can capture the attention of the justices. This leads to one of the most striking differences between a Supreme Court advocate and a regular lawyer: the rise of the repeat players. The bar that argues before the Supreme Court is shockingly small. In any given term, a huge percentage of the arguments are made by a tiny group of maybe 25 to 50 lawyers. You see the same faces at the lectern again and again. Names like Paul Clement, who has argued over 100 cases, Neil Katyal, a former acting Solicitor General, Lisa Blatt, the woman with the most Supreme Court arguments in history. Why does this happen? The answer is credibility. The stakes at the Supreme Court are astronomical, and the justices have no time to waste. When a known repeat player stands up, the justices know they are in good hands. They know the lawyer will be impeccably prepared, won't make frivolous arguments, and will be able to answer their questions directly and intelligently. They have a proven track record. Hiring one of these advocates is a signal to the court that the client takes the case seriously. For a lawyer arguing their first and only case, the challenge is immense. They are an unknown quantity. The repeat player, on the other hand, has a long-established relationship and reputation with the very jury they are trying to persuade. It's an almost insurmountable advantage. This entire journey fundamentally shapes the skill set of a Supreme Court lawyer, making it profoundly different from that of a trial lawyer. A brilliant trial lawyer is a master of facts, evidence, and human emotion. Their job is to weave a compelling narrative for a jury of 12 regular citizens. They question witnesses, present physical evidence, and make impassioned closing arguments. Their performance is often dramatic, designed to connect on a personal, relatable level. A Supreme Court lawyer's job is almost the polar opposite. Their audience isn't a jury. It's 9 of the sharpest legal minds on the planet. They aren't arguing about who ran a red light. They are engaging in a high-level, abstract debate about the meaning of the Constitution, the interpretation of complex statutes, and the entire history of American law. Their performance isn't about emotion. It's about pure, unadulterated intellectual horsepower. It's a Socratic dialogue, a high-speed chess match where every word is a move and every question from the bench is a potential checkmate. A trial lawyer tells a story. A Supreme Court advocate defends a thesis. Being a master of one does not make you a master of the other. They are 2 entirely different sports. So you've survived this brutal pipeline. You've clerked for a justice, you've trained in the Solicitor General's office, or you've risen to the top of an elite appellate practice. You are now one of the chosen few, a member of the most exclusive legal club in the world. But getting there was only half the battle. Now you have a case, and you must prepare for the single most important 30 minutes of your professional life. The process that comes next is a mind-bending, all-consuming ritual of preparation that would crush most ordinary lawyers. And it all begins long before you ever step foot in the courtroom, with a single critical document that holds the key to everything. That document is called the merits brief. And while every lawyer files briefs, comparing a brief filed in a local county court to one filed at the United States Supreme Court is like comparing a paper airplane to a stealth bomber. They both fly, but they are not in the same reality. For a regular lawyer, a brief is often a functional, necessary document. It lays out the facts, cites the relevant local statutes and case law, and makes a direct argument to a single judge. It's a roadmap. Here are the facts, here's the law, here's why we should win. It's persuasive, sure, but its universe is confined to the specific dispute between 2 parties. The Supreme Court merits brief is an entirely different creature. It's not a roadmap. It's a declaration of intellectual and philosophical war. It's not just for one judge. It's for 9 of the most powerful legal minds on the planet, each with their own judicial philosophy, their own legacy to consider, and their own team of brilliant eagle-eyed law clerks ready to tear your argument to shreds. This document is the first, best, and sometimes only real chance to win the case. The oral argument you see on TV? That's the flashy 30-minute finale. The brief is the silent, 9-month siege that precedes it. Many justices will tell you they have a very good idea of how they're going to vote after reading the briefs, long before the lawyer ever says, "Mr. Chief Justice." So what makes it so different? First, the stakes. A regular lawyer is arguing about their client's specific situation. A Supreme Court lawyer is also arguing for their client, but they are doing so on a national stage. The central question is not just did this person get a fair shake, but what rules should we create for 330 million Americans based on this person's problem? Your brief can't just talk about the facts of your case. It must talk about history. It must talk about the economy. It must talk about the societal impact of the decision you're asking for. You have to paint a picture of the future, showing the court the world they will create if they rule in your favor, and the chaos or injustice that will ensue if they don't. This requires crafting something called the theory of the case. This is the single, elegant, and powerful core idea of your argument. It's not just a collection of legal points. It's the story. It's the theme. It's the simple, compelling narrative that a justice can grab onto and use to persuade their colleagues in their private conferences. Finding this theory is an art form. It has to be simple enough to be remembered, but profound enough to withstand the most intense intellectual scrutiny imaginable. A regular lawyer might argue that a specific search was illegal based on a local precedent. A Supreme Court lawyer has to frame that same search as a fundamental turning point in the balance between privacy and state power in the digital age. See the difference? One is a legal dispute. The other is a battle for the soul of the Fourth Amendment. To build this intellectual weapon, the process is grueling and collaborative in a way most lawyers never experience. A Supreme Court advocate doesn't just sit down and write the brief. They assemble a team. This is a brain trust of the highest order, often including other top appellate lawyers, law professors who are leading experts in that specific field, and crucially former Supreme Court clerks. These former clerks are the ultimate insiders. They have spent a year, sometimes 2, inside the Marble Palace. They know how the justices think. They know what arguments will appeal to Justice Kavanaugh, what historical sources Justice Gorsuch finds persuasive, what kind of data-driven analysis might catch the eye of Justice Kagan. They understand the secret language and internal dynamics of the court. The team then wages a war on 2 fronts. The first is research. They don't just look at the last few relevant cases. They go back decades, sometimes centuries. They pull the original transcripts from the Constitutional Convention. They read the private letters of the Founding Fathers. They analyze British common law from the 1700s. They commission statistical studies. They read sociology papers. They are searching for the intellectual ammunition to make their theory of the case unassailable. The second front is the writing, and this is where the real pain begins. The Supreme Court has brutally strict page and word limits. You might have a mountain of research and a dozen complex legal arguments, but you have to distill it all into a document that is ruthlessly concise. Every single word is fought over. Every sentence is structured, debated, torn down, and rebuilt. The goal is absolute clarity and devastating logic. There can be no fat, no wasted words, no ambiguity. It has to be so clear that a justice, reading it at 11 p.m. after a long day, immediately grasps the power of your position. This process is called mooting the brief, or sometimes, more violently, murderboarding it. The draft brief is circulated to a team of fresh, hostile eyes. Their job is not to be polite. Their job is to destroy it. They attack every premise. They question every source. They poke holes in every logical leap. This sentence is weak. Justice Alito will never buy this. You cite this case, but you ignore the dissent, which is where the real action is. It is a humbling, ego-crushing process of intellectual combat. The brief is forged in this fire. What survives is lean, powerful, and battle-tested. Compare this to a regular lawyer, who often writes their briefs alone or with a single partner, under tight deadlines, juggling multiple cases. They simply don't have the time, the resources, or frankly, the necessity for this level of obsessive perfection. Their brief needs to be good. The Supreme Court brief needs to be a masterpiece. When it's finally done, printed on specific high-quality paper, bound in a specific color depending on which party you are, and filed with the clerk of the court. It is more than just a legal document. It is the culmination of thousands of hours of the most intense intellectual labor imaginable. It's a work of history, a work of rhetoric, and a strategic blueprint for victory. It is designed to persuade at least 5 of 9 individuals that your vision for America is the correct one. But here's the terrifying part. After all that work, after crafting this perfect document, your opponent does the exact same thing. They file their own brief with their own team, their own theory, and their own masterpiece of persuasion. And now the justices have both. Your flawless argument is sitting right next to your opponent's flawless argument. The written war has been fought to a standstill. And that is when the advocate must step out from behind the pages. They must prepare to stand alone for 30 minutes and face the 9 justices in person. The brief was the weapon. Now the lawyer must become one. And that transformation is even more demanding. This transformation from scholar to gladiator doesn't happen in a quiet office. It happens in a crucible. It happens in a series of brutal high-stakes dress rehearsals known as moot courts. Now, you might have heard of moot court from law school. It's a student competition, a simulation. But at the Supreme Court level, this is no academic exercise. This is the legal equivalent of a special forces team running a kill house simulation with live ammunition. These sessions are so intense, so unforgiving, that insiders have a different name for them: murder boards. A regular lawyer preparing for a big trial focuses on logistics. They prep their witnesses, organize mounds of evidence, and outline their opening and closing statements. They might run their arguments by a partner, maybe even role-play a cross-examination. It's a process of assembling a complex machine of facts and testimony. The Supreme Court advocate's preparation is entirely different. They are not assembling a machine. They are forging a single, perfect blade and learning how to wield it with lethal precision. Their evidence is already submitted. Their witnesses will never be called. There is only their argument, their intellect, and the 9 minds they must persuade. So, the advocate schedules their first moot court, typically 3 to 4 weeks before the actual argument. And who sits on the other side of the table, acting as the justices? It's not junior associates. It's a panel of legal titans. Think former solicitors general, people who have argued dozens of cases themselves. Think renowned law professors who have written the definitive books on that specific area of law. Think retired federal appellate judges who have spent decades asking the very same kinds of questions. This isn't a friendly warm-up. It's an ambush by a team of experts whose sole mission is to find every single flaw in the advocate's case and exploit it mercilessly. The advocate stands at a lectern, clears their throat, and begins. "Mr. Chief Justice, and may it please the court." They might get 5 words out, maybe 10, before a hand shoots up. A justice on the panel leans forward. "Counsel, before you proceed, could you explain how your proposed rule wouldn't completely upend a century of precedent in maritime law?" And just like that, the onslaught begins. For the next 30 minutes, it is a relentless barrage. They interrupt. They talk over each other. They pose absurd hypotheticals designed to stretch the lawyer's logic to its breaking point. "Counsel, what if the facts were slightly different? What if the plaintiff was an alien from another planet? What is the limiting principle of your argument? Where does your rule stop?" This last question, what is the limiting principle, is the stuff of nightmares for Supreme Court advocates. It's a deceptively simple question that's designed to expose whether the lawyer's argument is a carefully constructed legal principle or just a convenient excuse to win this one case. If you argue that a certain action is illegal, they want to know what other actions would become illegal under your new rule. If you can't draw a clear logical line, your entire argument collapses. It shows you haven't thought through the consequences, and the court, which has to think about how its decisions will affect the entire country for decades, will not adopt a rule with unknown and potentially chaotic consequences. During these murder boards, every crutch is kicked away. Every weak phrase is pounced on. Every hesitant answer is a signal to press harder. The advocate might have a brilliant point they're trying to make, but the panel will intentionally steer them away from it, testing their discipline. Can they pivot back to their core message? Or will they get lost in the weeds chasing hypotheticals? The goal is to simulate the terrifying reality of a hot bench. A Supreme Court session where the justices are highly engaged, firing questions one after another, leaving the lawyer with no time to think, only to react. After the 30 minutes are up, the advocate is usually drenched in sweat, their confidence shattered. Then comes the feedback session, which can be even more brutal. The panel dissects their performance, piece by piece. Your answer on page 12 of the respondent's brief was weak and unconvincing. You completely missed the point of Justice Kagan's likely question on statutory interpretation. When you said, "I think," you sounded uncertain. Never say "I think." You must believe or submit that your position is correct. They are not just critiquing the argument, they are re-engineering the advocate's entire way of thinking and speaking. And the advocate doesn't do this just once. A top-tier lawyer will do 5, 6, sometimes more than 10 of these murder boards. They'll do one with a panel of academics to test the intellectual rigor. They'll do another with former government lawyers to test the practical implications. They'll do one with subject matter experts. Each time the argument is refined, sanded down, and polished. Weak points are fortified or abandoned entirely. New, more persuasive ways of framing the issue are discovered. The lawyer learns the entire universe of their case. They internalize every precedent, every statute, every scholarly article, not as a list to be memorized, but as a mental landscape they can navigate instantly. This is perhaps the most fundamental difference. A trial lawyer prepares a script. They have their opening, their questions for witnesses, their closing. The Supreme Court advocate prepares for a conversation, a 30-minute oral examination from 9 of the smartest legal minds alive. Memorizing a speech is not only useless, it's a liability. The moment a justice asks a question, the script is irrelevant. The preparation, therefore, is not about memorizing lines. It's about achieving a state of complete intellectual mastery. It's about building a mental palace where every room, every hallway, every possible permutation of the argument has been explored and mapped. The advocate needs to know the case so perfectly that they can answer any question from any angle without a moment's hesitation, and seamlessly weave that answer back into the 1, 2, or at most 3 key themes they need to hammer home. So when you watch a Supreme Court oral argument and see a lawyer standing calmly at the lectern, effortlessly fielding complex questions, remember the unseen gauntlet they endured. They have walked through fire to get there. They have been intellectually dismantled and reassembled multiple times. Their confidence isn't arrogance. It's the hard-won product of extreme preparation. They have faced panels far more hostile than the one they face now. They have answered questions far more difficult. The briefs have been filed. The murder boards are complete. The advocate has honed their arguments to a razor's edge. Now all that's left is the day itself. The early morning in Washington, D.C., the walk past the news cameras and the protesters, the climb up the 44 marble steps of the United States Supreme Court building. They enter a world of hushed tones, of crimson draperies and ionic columns. They take their seat at the counsel table, a place fewer than 1% of all American lawyers will ever occupy. And they wait. They wait for the sound of a gavel and the historic cry that has echoed through that chamber for nearly a century, signaling that the ultimate intellectual test is about to begin. Voyez, voyez, voyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The marshal's cry slices through the silent tension. The red velvet curtains part, and 9 figures in black robes emerge, taking their seats behind the long, elevated mahogany bench. This is not a courtroom, it is a crucible. And for the advocate standing at the lectern, the 30 minutes they have been allotted will feel like both a lifetime and the blink of an eye. This is where the abstract theories of law, the years of preparation, and the fate of millions collide with the raw Socratic power of 9 brilliant minds. The first mistake a regular lawyer would make is thinking this is a speech. It's not. It's a conversation. A very, very dangerous conversation. The advocate's opening words are perhaps the most critical part of their entire presentation. They have maybe 90 seconds if they're lucky before the first question hits. In that brief window, they cannot simply recite the facts. They must frame the entire universe of the case. They must plant their flag on the intellectual high ground, presenting a simple, powerful, and compelling theory of why they should win, a theory so clear and intuitive that it can serve as an anchor for the justices when the legal waters get choppy. And they will get choppy. Immediately. The questioning at the Supreme Court is unlike any other legal proceeding on earth. It is a hailstorm of intellectual inquiry. In a lower court, a lawyer might face questions from a single judge, or perhaps a panel of 3. The questions are often clarifying, focused on the record of the case below. At the Supreme Court, the lawyer is facing 9 different interrogators, each with their own lifetime of legal philosophy, their own concerns, their own agenda for the argument. They don't wait their turn. A justice will interrupt the lawyer mid-sentence. Then, another justice will interrupt the first justice to reframe the question or challenge its premise. A third justice might then jump in to defend the lawyer from the other two, only to pivot and ask an even more difficult question. The advocate is a ship captain in a hurricane, navigating cross-currents of thought from every direction at once. They are not just answering questions, they are managing a chaotic, high-stakes, multi-party negotiation in real time. The questions themselves are the real differentiator. A regular lawyer is used to questions about what happened. Mr. Smith, on what date did your client sign the contract? The Supreme Court advocate is almost never asked about what happened. The facts are assumed. They are asked about what happens next. The questions are almost entirely about the consequences of their argument. They are an endless stream of brutal hypotheticals designed to test the logical limits of the lawyer's position. Counsel, if we rule in your favor today, what does that mean for environmental regulations in the state of California? If we accept your interpretation of this statute, does that mean we invalidate 100 years of maritime law? Let's imagine a scenario where a first grader brings a plastic butter knife to school. Under your proposed rule, could the school principal be sued for violating the student's constitutional rights? These aren't just questions, they are traps. They are invitations to walk down a logical path that ends in an absurd result, thereby proving the lawyer's core argument is flawed. The advocate must see the trap from miles away. They must understand the legal and philosophical principle behind the justice's hypothetical, address it head-on, and pivot back to the safety of their central theme, all without missing a beat. This is the art of the off-ramp. An elite Supreme Court lawyer knows that directly answering some questions is a form of surrender. If a justice poses a hypothetical that is particularly damaging, the lawyer can't simply refuse to answer. But they can't afford to get bogged down in it either. The technique is to acknowledge the justice's concern. That is a serious concern, justice. Provide a very brief, targeted answer that satisfies the immediate inquiry, and then immediately bridge back to their main point. But that is not the case before the court today. The core issue here is, it's an act of intellectual judo, using the momentum of the question to return to a position of strength. And here is the secret that separates the masters from the novices. The lawyer at the lectern is not always trying to convince the justice who is asking the question. They're playing three-dimensional chess. The advocate might be getting hammered with hostile questions from Justice A, who has clearly already made up their mind. A lesser lawyer would get defensive and spend their precious time trying to win over the unwinnable. The master advocate understands that Justice A is a lost cause. Their real audience is Justice B and Justice C, the swing votes who are listening silently. The lawyer is performing for them. They are using their answers to Justice A's hostile questions as a vehicle to signal to the undecided justices, I understand your concerns. Here is why my rule is reasonable. Here is how you can join my side without opening the floodgates you're worried about. Every answer is a subtle appeal to a different part of the bench, an attempt to build a silent coalition of 5 votes. Think of the legendary advocate Paul Clement. During the landmark healthcare case, he was facing a barrage of questions from the liberal wing of the court about the limits of his argument against the individual mandate. He remained unflappable, his posture calm, his voice even. He never got rattled. He treated every question, no matter how aggressive, as a genuine and welcome inquiry. He wasn't just arguing the law. He was projecting an aura of supreme confidence and reasonableness. He was communicating non-verbally to the undecided Justice Kennedy. You can trust me. My position is not extreme. It is grounded in history and precedent. He was building credibility, not just making arguments. That is a skill far beyond what is taught in law school. This requires an almost superhuman level of mental processing. The advocate must simultaneously listen to the current question, formulate a precise and persuasive answer, remember their core themes, monitor the clock, watch the body language of all 9 justices, anticipate the next question, and recall specific lines from hundreds of relevant legal precedents, all while maintaining a calm, conversational demeanor. It is the ultimate intellectual tightrope walk. A regular lawyer prepares to give a presentation and answer a few questions. A Supreme Court lawyer prepares for a 30-minute oral exam on the entirety of American law, history, and philosophy, administered by the 9 most qualified examiners in the nation, with the whole country watching. Their goal isn't to score points or deliver a zinger that will end up on the news. Their goal is to gently guide the conversation, to probe for the court's anxieties, and to provide the undecided justices with the intellectual architecture they need to write an opinion in their favor. They are not there to win the argument. They are there to give the justices the tools to win it for them, weeks later, in the quiet solitude of their chambers. This is why the preparation for a Supreme Court argument is unlike anything else in the legal world. It's not about memorizing a speech, it's about building a fortress. A regular lawyer preparing for a trial court might spend hours reviewing evidence, prepping witnesses, and outlining their closing statement. They're preparing for a battle of facts. But the Supreme Court advocate is preparing for a battle of ideas, a philosophical stress test conducted at the highest possible level. And to do that, they must go through a gauntlet known as the moot court. Now, a moot court isn't a new concept. Law students do them all the time. It's a practice argument. But a moot court for a Supreme Court case is a different beast entirely. It's less like a scrimmage and more like a controlled demolition. The advocate will stand at a podium, identical to the one in the real courtroom, and face a panel of mock justices. But this isn't just a random group of colleagues. The panel is a carefully curated murder board of the sharpest legal minds they can find. Who is on this board? Former solicitors general, law professors who are the leading experts in that specific field of law, and, most importantly, former Supreme Court clerks. These are the men and women who recently worked inside the chambers, who helped the justices draft opinions, who know exactly how each justice thinks, what their pet peeves are, and what questions they are almost certain to ask. They are the ultimate insiders. Their job in the moot court is to be ruthless. They don't just ask questions, they launch intellectual assaults. They interrupt. They play devil's advocate with brutal efficiency. They poke, they prod, they try to knock the advocate off balance to find the single weakest link in the chain of their logic. An advocate might go through 3, 4, even 5 of these murder boards before the real argument. Each one is a grueling 90-minute session designed to simulate and exceed the pressure of the actual event. The goal isn't to win the moot. The goal is to lose, and lose badly. The goal is to have your argument so thoroughly dismantled in private that by the time you stand before the 9 real justices, there is no question you haven't heard, no attack you haven't weathered, no logical flaw you haven't patched. A trial lawyer prepares to tell a story to a jury. A Supreme Court lawyer prepares to defend a dissertation to a panel of 9 Nobel laureates who have all written books on the topic. It is a fundamentally different kind of intellectual preparation. This intense, specialized process gives rise to another major difference: the existence of an elite, informal group known as the Supreme Court Bar. This isn't just a list of lawyers who are technically admitted to practice before the court. It's a tiny club of maybe a few dozen advocates, mostly based in Washington, D.C., who handle a shocking percentage of the cases argued each year. Think of them as the special forces of the legal world. When the stakes are at their absolute highest, these are the people who get the call. Names like Paul Clement, who has argued over 100 cases before the court. Neil Katyal, a former acting Solicitor General with dozens of arguments under his belt. Lisa Blatt, the woman who holds the record for the most Supreme Court arguments by a female advocate. These are the repeat players. They are, in a sense, a 10th justice in the room. They understand the institution from the inside out. They know that Justice Kagan is likely to press them on the practical consequences of their proposed rule, that Justice Gorsuch will zero in on the original meaning of the text, and that the Chief Justice will be intensely focused on the institutional role of the court itself. This familiarity is a massive, almost unquantifiable advantage. A local lawyer from, say, Des Moines might be a brilliant attorney who has won countless cases in Iowa. But if their case gets to the Supreme Court, it's the first and likely the only time they will ever stand in that room. They don't know the justices' individual quirks. They don't have the same level of credibility that comes from being a known quantity. The justices might listen to the lawyer from Des Moines, but they know the advocate from the Supreme Court Bar. They've seen them perform under pressure a dozen times before. There is an implicit trust, a shorthand in communication, that a newcomer simply cannot replicate. Because of this, a strange and fascinating phenomenon occurs. Very often, the lawyer who argued the case in the trial court, and then in the Court of Appeals, is not the lawyer who argues it at the Supreme Court. A company might have its trusted corporate counsel handle a dispute for years, winning at every stage. But once the Supreme Court agrees to hear the case, a moment that happens for less than 1% of petitions, the game changes. The client, understanding that this is the final appeal, the last stop, will often make the difficult decision to bring in a hired gun, a specialist from the Supreme Court Bar. It's not a knock on their original lawyer. It's an acknowledgement of specialization. You wouldn't have your family doctor perform open heart surgery. Even if they are a fantastic doctor, you want the specialist who does nothing but that one specific high-stakes procedure. The original lawyer becomes a vital part of the team, providing the deep factual knowledge of the case's history, while the Supreme Court specialist takes over as the architect and spokesperson for the final, critical argument. Their job is to translate the complex facts and lower court history into the language the Supreme Court speaks. The language of constitutional structure, statutory interpretation, and sweeping legal precedent. This level of specialization, of course, comes at a staggering cost. The top-tier advocates and their teams at major law firms can bill upwards of $1 million, sometimes more, for a single Supreme Court case. The process of preparing the initial petition, writing the briefs if the case is taken, and conducting the intensive moot court preparations involves thousands of hours of work from the most expensive legal talent on the planet. For the corporations and industries fighting over regulations worth billions, it's a worthy investment. A single favorable sentence in a Supreme Court opinion can reshape an entire market. But it's not just a playground for the rich. To their credit, this same elite bar is also responsible for a huge amount of high-level pro bono work. The very same lawyers who charge corporations $1,000 an hour will turn around and represent an indigent criminal defendant or a civil rights plaintiff for free. They do it for prestige, for a sense of public duty, and because these are often the most legally interesting and historically significant cases. It creates a strange paradox, where the most expensive legal talent in the country is sometimes available for free, but only if your case is important enough to capture their attention and advance a cause they believe in. This entire ecosystem, the brutal moot courts, the tiny club of repeat players, the hired gun phenomenon, is built around optimizing for those 30 precious minutes of oral argument. It's an attempt to control for every variable and leave nothing to chance. But even with all this preparation, and with the most elite advocate at the podium, the fate of the case often rests not on the performance in that half hour, but on the 9 brilliant and often invisible young minds who have already spent months living with the case, and whose memos are waiting on the justices' desks. These are the Supreme Court law clerks, and they are arguably the most powerful legal figures in America that you have never heard of. For the one-year term they serve, these recent law school graduates operate as the intellectual engines and gatekeepers of the highest court in the land. Their influence is so profound, it's almost impossible to overstate. To understand how a Supreme Court lawyer truly operates, you have to understand the 36 individuals they are often trying to persuade first. Let's start with the front door of the court, the petition for a writ of certiorari. Every year, between 7,000 and 8,000 cases appeal to the Supreme Court, begging for a hearing. 7,000 to 8,000. The justices, for all their brilliance, cannot possibly read every single one. It's a logistical nightmare. So in the 1970s, the court developed a system to manage the flood, the cert pool. All the justices, except for Justices Alito and Gorsuch, who have their clerks review everything independently, participate in this pool. The thousands of petitions are divided up among the clerks of the participating justices. A single clerk is assigned a batch of cases and is tasked with writing a single memo for all the justices in the pool summarizing each case, and most importantly, recommending whether the court should take it. This document, the cert memo, is the first and often the last word on a case's life. In just a few pages, the clerk summarizes the facts, outlines the legal arguments from both sides, analyzes whether the case meets the court's criteria for review, like a split among the lower courts, and then provides a recommendation, grant, deny, or sometimes relist for a future conference. Think about the staggering power of that. A 20-something-year-old, just a year or two out of law school, writes a memo that lands on the desks of the most powerful judges in the nation, and their recommendation can effectively end a multi-year, multi-million-dollar legal battle before a single justice has devoted more than a few minutes to it. If that clerk's memo recommends deny, and does so persuasively, the case is likely dead on arrival. It's the ultimate filter. For a case to even be discussed by the justices in their private conference, it must first make it onto the discuss list. Any single justice can add a case to this list, but their decision to do so is almost always informed by that clerk's cert memo. The Supreme Court advocate, therefore, isn't just writing their brief for 9 justices. They are writing it for a hyper-intelligent, skeptical, and overworked law clerk who holds the key to the first gate. Their brief needs to be so clear, so compelling, and so undeniably important that it screams grant to the young clerk reading it at 1 a.m. on a Tuesday. So who are these prodigies? Getting a Supreme Court clerkship is the single greatest prize a law school graduate can achieve. It's the legal world's equivalent of winning a golden ticket. The typical clerk is not just a top student. They are a legal unicorn. They graduated at the absolute apex of their class from Harvard, Yale, or Stanford. They were likely the editor-in-chief of their school's prestigious law review. But that's just the baseline. Before they even apply to the Supreme Court, they will have almost certainly completed another clerkship for a highly respected judge on a federal court of appeals, specifically one known as a feeder judge. Judges like J. Harvey Wilkinson III on the Fourth Circuit or Merrick Garland before he became Attorney General, whose own former clerks are so brilliant they have a proven track record of getting hired by the Supreme Court justices. The competition is a crucible. Hundreds of the nation's brightest legal minds apply for just 36 slots each year. The justices look for more than just grades. They seek out transcendent writers, razor-sharp analytical minds, and an inexhaustible work ethic. And often, they look for a degree of ideological compatibility. A conservative justice is more likely to hire clerks from conservative legal circles, and a liberal justice from liberal ones. They aren't looking for a yes man, but for someone who can challenge them within a shared judicial philosophy, someone who can make their arguments stronger by stress-testing them from every angle. Once they arrive, the life of a clerk is a year-long sprint of intellectual exertion. The hours are brutal, the pressure immense. Their duties extend far beyond just reading petitions. When the court does agree to hear a case, the clerks are the ones who prepare their justice for battle. They dive deep into the record, reading every brief, every cited case, every law review article even tangentially related to the issue. They then synthesize all of this information into a bench memo, a detailed document that arms the justice for oral argument. This memo outlines the strongest and weakest points for each side, anticipates the arguments the lawyers will make, and, crucially, suggests a battery of tough questions for the justice to ask from the bench. So when you see a justice back a lawyer into a corner with a devastatingly precise question, there's a very good chance that question was born from a late-night brainstorming session with a clerk. But perhaps their most significant and least understood role comes after the argument, once the justices have voted in their private conference. The Chief Justice, if in the majority, or the most senior justice in the majority, assigns a justice to write the court's official opinion. And who do you think writes the first draft of that opinion? It's not the justice. It's the clerk. Let's be clear. The justice sets the direction. They provide the core reasoning, the legal framework, and the ultimate conclusion. They are the architect. But the clerk is the master builder. The clerk takes that blueprint and constructs the argument brick by brick. They find the supporting case law, craft the sentences, structure the paragraphs, and build the initial draft of the very words that will become the law of the land. The draft then goes through a painstaking editing process, a back and forth between the clerk and the justice, sometimes going through dozens of revisions. They debate word choices, refine legal reasoning, and polish the prose until the justice is satisfied that it perfectly reflects their voice and their judgment. The same process happens for dissenting and concurring opinions. A clerk's ability to channel their justice's voice and craft a powerful, persuasive argument is paramount. A single elegant turn of phrase from a clerk's draft might become the most iconic line from a landmark decision, quoted for generations. This is an apprenticeship of unparalleled intimacy. For 1 year, four young clerks get a front-row seat to the mind of a Supreme Court justice. They become trusted sounding boards, debate partners, and intellectual confidants. They are in the room as history is being made, not as observers but as active participants. They are the ones who can say, "Justice, with all due respect, I think there's a flaw in that line of reasoning," and be taken seriously. This 1-year trial by fire doesn't just end with a great line on a resume. It forges the future leaders of the American legal system. The alumni network of former Supreme Court clerks is often called the clerkship mafia. It is the most elite, exclusive club in law. These former clerks go on to become partners at the most powerful law firms, tenured professors at the most prestigious law schools, and occupy the highest ranks of the Department of Justice. They become federal judges themselves, and in some cases they come full circle. Today, 6 of the 9 sitting justices, Chief Justice John Roberts and Justices Elena Kagan, Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett, and Ketanji Brown Jackson, all began their careers right there as clerks in the very institution they now lead. They were once the invisible minds behind the throne. Now they sit on it. The Supreme Court bar knows this. They know that to win a case, you must first win over the clerks, the brilliant, tireless, and profoundly influential guardians at the gate. And winning over those clerks isn't about sending a gift basket. It's about crafting a document so clear, so persuasive, and so intellectually airtight that a brilliant, skeptical, and overworked clerk has no choice but to say, "This is the argument we need to take seriously." This is where the Supreme Court lawyer truly separates from the pack. It's in the written word. It's on the page. It's in the brief. To a regular lawyer, a legal brief is often a brute force instrument. It's a document designed to overwhelm. It can be 100 pages of dense, jargon-filled prose, citing dozens, sometimes hundreds of cases. The strategy is often one of attrition. Bury the opposing counsel and the judge in a blizzard of paper, citations, and convoluted arguments. It's a kitchen sink approach. Throw every possible argument at the wall and pray something sticks. This might work for a highly specific commercial dispute in a state court, where the judge is an expert on that single area of law and has the time to sift through the mess. A Supreme Court brief is the polar opposite. It is not a blizzard, it is a laser. It is an exercise in radical simplicity and devastating clarity. These lawyers understand they are not writing for a specialist. They are writing for 9 of the most intelligent legal generalists on the planet. Chief Justice Roberts is not an expert in patent law. Justice Kagan is not a specialist in ERISA regulations. They are brilliant minds who must parachute into a dozen different fiendishly complex areas of law every single term. And so, the brief cannot be a dense thicket of jargon. It must be an open, inviting path. It must tell a story. It all starts with something that sounds deceptively simple. The question presented. In a normal legal filing, this is an afterthought, a dry statement of the legal issue. For a Supreme Court advocate, the question presented is the entire war, fought in 25 words or less. It is the first thing the justices and their clerks read, and it is meticulously engineered to frame the entire case in their favor. A regular lawyer might write, whether the appellate court erred in its application of the Clean Water Act to the petitioner's property. It's accurate, but it's dead on the page. A Supreme Court specialist like the legendary Paul Clement might frame the exact same issue like this. Whether the Clean Water Act gives the federal government the power to regulate a homeowner's backyard pond that is miles from any navigable waterway and has no connection to interstate commerce. Do you see the difference? The first is a neutral question. The second is an argument. It's already telling a story. It invokes images of government overreach, a simple homeowner, and a harmless backyard pond. It subtly defines the terms of the debate before the first fact is even mentioned. They are playing chess while everyone else is playing checkers, and they've already moved their queen before their opponent even knows the game has begun. This storytelling continues into the body of the brief. These elite advocates are masters of narrative. They don't just recite facts. They weave them into a compelling arc. They find the human element. Their client isn't just the petitioner. They are a family farmer trying to protect their land, an inventor whose life's work was stolen, a small business being crushed by nonsensical regulations. They create a narrative where the justices can see a clear protagonist, a clear principle at stake, and a clear just outcome, which just so happens to be ruling in their client's favor. And they do it with a relentless focus on a single powerful idea: the theory of the case. A regular lawyer might offer the court 5 different reasons why they should win. This seems smart, like you're giving the judge options. But to a Supreme Court justice, it just signals a lack of confidence. It's messy. The elite advocate does the hard work of distilling their entire complex case down to one elegant and easily digestible theme. A single sentence that explains why they are right. For example, in a First Amendment case, the theory might be, the government cannot compel a private citizen to speak a message they disagree with. Period. Every fact, every case citation, every argument in the brief is then marshaled in service of that one central theory. It creates a document with immense gravitational pull, where every element reinforces the core. They also show a sophisticated understanding of the court as an institution. They know the justices are wary of making sweeping, radical changes to the law. So, a key part of their written strategy is to provide the court with an off-ramp. This is a narrow, limited way for the court to rule in their favor without blowing up decades of precedent. It's a way of saying, you don't have to cause a legal earthquake to side with us. Here is a small, surgical, and logical step you can take that fixes this problem without creating 1,000 new ones. This gives the justices a sense of safety. It shows respect for their role as stewards of the law, not just arbiters of a single dispute. It's a sign of a master craftsman who understands their materials. This strategic architecture extends beyond their own brief. The elite Supreme Court bar are conductors of a legal orchestra. They don't just write their own music. They coordinate the entire symphony. This is done through the strategic use of amicus curiae, or friend of the court briefs. In a typical case, amicus briefs are a bit of a free-for-all. Any interested group can file one, and they often just repeat the same arguments. Not here. The top advocates in their firms actively recruit and coordinate their amici. They will get a group of distinguished law professors to file a brief focused on the complex historical analysis. They'll get a coalition of industry groups to file another focused on the devastating economic impact of the lower court's ruling. They'll encourage a civil rights organization to write about the social consequences. They'll even get former government officials to file a brief explaining how the ruling would make the government's job impossible. Each amicus brief is a different instrument, playing a different part, but all contributing to the same powerful harmony. When the justices and their clerks look at the case, they don't just see one lawyer making an argument. They see a powerful chorus of the nation's leading experts, all saying the same thing. You must rule for this side. And before any of these briefs are filed, before a single word is ever spoken in the courtroom, the argument goes through a trial by fire. This is the world of the moot court. A regular lawyer might prepare for an argument by reviewing their notes or talking it over with a colleague. A Supreme Court advocate is put through a gauntlet. They will stand in a mock courtroom, often at a place like Georgetown University Law Center, and face a panel of mock justices. But these aren't law students. They are the killers. They are former solicitors general, former high-ranking DOJ officials, and most importantly, former Supreme Court clerks, people who know exactly how the justices think, what their hot-button issues are, and what questions they are likely to ask. And these moots are brutal. They are designed to be 100 times harder than the real thing. The mock justices don't let the lawyer get through their opening sentence. They interrupt, they cross-examine, they attack every premise. They ask impossibly hard hypotheticals. They play devil's advocate with relish. Counsel, if we rule for you, wouldn't that mean X? But what about your argument in light of this obscure case from 1923? How do you reconcile that with what Justice Gorsuch wrote in his dissent 2 years ago? The lawyer will go through this process not once, not twice, but sometimes 5 or 6 times. Each time their arguments are torn apart, their weaknesses exposed, their answers found wanting. And each time they go back, rewrite their arguments, sharpen their answers, and patch the holes in their intellectual armor. By the time they step up to the real podium in the real Supreme Court, they have already faced down every conceivable question, every possible attack from every ideological angle. The oral argument becomes less an act of improvisation and more the final polished performance of a script that has been rehearsed, rewritten, and perfected through relentless, punishing practice. The brief is the blueprint. The moot court is the forge. And what emerges is an argument that is not just persuasive, but nearly indestructible. This indestructible argument, this polished weapon of logic and law, is then carried into one of the most intimidating rooms in the entire country, the courtroom of the Supreme Court of the United States. And on the day of oral argument, the difference between the elite advocate and a regular lawyer becomes a chasm. For most lawyers, a court appearance is a routine part of the job. It's walking into a familiar county courthouse, a place with scuffed floors and the lingering smell of stale coffee. They know the clerks, they know the bailiffs, they probably know the judge from a local bar association event. The atmosphere is professional, but it's fundamentally a workplace. The Supreme Court is not a workplace. It is a temple. The moment an advocate walks up those marble steps, under the inscription "Equal Justice Under Law," they are entering a different reality. The air itself feels heavier, charged with history and consequence. The chamber is smaller than most people imagine, creating an almost shocking intimacy. The advocate stands at a lectern, just feet away from 9 of the most powerful legal minds on the planet, robed in black, sitting beneath a massive ornate ceiling. There is no jury to charm. There is no gallery to play to. There is only the advocate, the lectern, and the 9. The silence before the Chief Justice says, "We will hear argument this morning in case 22-506, is a profound, deafening quiet, a world away from the controlled chaos of a local trial court. And then the clock starts. This is perhaps the most brutal and defining difference. A regular trial can last days, weeks, even months. Lawyers have hours for opening statements, for direct examination, for closing arguments. They have time to build a narrative, to develop a rhythm. A Supreme Court advocate gets 30 minutes. That's it. 1/2 of 1 hour to defend a position that could alter the course of the nation. Every second is priceless. There is no room for throat clearing, for rambling introductions, or for rhetorical flourishes that don't serve a direct purpose. The entire argument must be a masterpiece of compression, a legal theory so refined and distilled that it can be powerfully conveyed in the time it takes to watch a sitcom. But here's the real kicker: the trial by fire that separates this league from all others. The advocate doesn't actually get 30 minutes to give a speech. They get 30 minutes to be interrogated. In a lower court, a lawyer can often deliver a significant portion of their prepared argument before the judge interjects. At the Supreme Court, an advocate is lucky if they get past their first sentence. "Mr. Chief Justice, and may it please the court." And bam, a question comes from the bench. And then another, and another. The 30 minutes becomes a rapid-fire intellectual gauntlet. This isn't heckling. It's the Socratic method at its most extreme. The justices have already read the briefs. They've read the lower court opinions. They've had their clerks research every facet of the case. They don't need the lawyer to summarize the facts. They are there to test the argument's breaking points. They will push the advocate with hypotheticals, often taking their logic to its most absurd conclusion to see if it holds up. "Counsel, if we accept your argument about this specific regulation, does that mean Congress could also regulate what people eat for breakfast? Where is the limiting principle?" They are probing for weakness, trying to understand the downstream consequences of a potential ruling. It's less of a presentation and more of a live high-wire stress test. And the skill required to navigate this is monumental. A regular lawyer, when asked a tough question by a judge, might say, "Your Honor, I'll address that point later in my argument." At the Supreme Court, that's a fatal mistake. The answer is now. The advocate must answer the justice's question directly, respectfully, and most importantly, immediately. They have to give a concise, brilliant answer to a complex hypothetical, and then, and this is the true art, seamlessly pivot back to the core theme of their argument, all without missing a beat. It requires a level of mental agility that is simply breathtaking. They have to hold their entire prepared argument in their head like a complex web, and be able to jump to any point in that web, address a challenge, and then jump back to their planned path, all while a clock is ticking down to zero. Compounding this difficulty is the fact that they aren't talking to a single judge. They are addressing 9 of them, and they are not a monolith. An advocate for the Supreme Court is playing 9 different games of chess simultaneously. They need to know that Justice Kavanaugh might be concerned about the historical precedent, while Justice Sotomayor might focus on the real-world impact on ordinary people, and Justice Gorsuch might be focused on the precise textual meaning of the statute. The advocate's answers must be tailored in real time to persuade these different judicial philosophies. A single sentence might be crafted to reassure one justice while simultaneously winning over another. They are constantly reading the room, watching the justice's body language, seeing who's nodding, who's frowning, who's leaning forward with a question. A trial lawyer is trying to convince a jury of 12 average citizens. A Supreme Court lawyer is trying to convince a panel of 9 legal giants, each of whom has a deeply developed, often publicly known, view of the law. It is the ultimate act of targeted persuasion. There's another player in this arena that has no equivalent in regular law: the Office of the Solicitor General. When the United States government is a party to a case, it is represented by the Solicitor General or one of their deputies. This lawyer is often referred to as the 10th Justice. They argue before the court so frequently, and the office is held in such high esteem, that their arguments carry a unique weight and credibility. The Solicitor General's office is a hyper-elite institution, a monastery of appellate advocacy, where lawyers do nothing but prepare for and argue cases at the highest level. The existence of this office further illustrates the specialization. Being a great trial lawyer doesn't mean you can do this job. This is a different sport played on a different field with a different set of rules. Finally, and most fundamentally, is the staggering weight of the stakes. A regular lawyer fights for their client. Their goal is to win money or freedom, or a favorable ruling for one person or one company. And that is a noble and difficult task. But the Supreme Court advocate is fighting for something more. They are fighting for precedent. The case may be about one person's dispute with their employer, but the court's decision will set the rule for every employee and employer in the country. The argument might concern a single environmental regulation on one river, but the outcome will define the scope of the Clean Water Act for generations. Every word spoken at that lectern could end up in a landmark opinion, quoted by judges and lawyers for the next 100 years. The advocate is not just representing a client. They are a temporary custodian of an idea that could become the law of the land. That pressure, the knowledge that your 30-minute performance will have consequences for millions of people you will never meet, is a burden that very few lawyers will ever have to bear. When the red light on the lectern flashes, signaling that their time is up, and the Chief Justice says, "Thank you, counsel," the argument is over. The months of preparation, the sleepless nights, the relentless moot courts, all culminate in that final, abrupt moment. The advocate sits down, their part in history finished, leaving their argument and the fate of the law in the hands of the nine. And in that silence, a new kind of pressure begins. The public battle is over, but the real war for the soul of the law has just moved behind closed doors, into a place where cameras can't go and sound is never recorded. For the lawyer who just sat down, the feeling is surreal. It's an adrenaline crash of monumental proportions. Every question they answered, every word they chose, now plays on an endless loop in their mind. Did they persuade Justice Kavanaugh? Was that hesitation from the Chief Justice a sign of doubt or agreement? The second guessing is a form of torture, but it's all they have. Because for them and for their client, there is nothing left to do but wait. But for the 9 justices, the work is just beginning. Shortly after the arguments conclude, usually on a Wednesday or a Friday, the justices walk through a thick, soundproof door into one of the most secret and consequential rooms in all of American government, the Justices' Conference Room. No one else is allowed inside. No clerks, no staff, no security. Just the 9 of them. By tradition, the most junior justice has the job of being the doorkeeper, sending and receiving messages to the outside world so no one else has to enter. The tradition starts with a handshake. They go around the room, each justice shaking the hand of every other justice. It's a small but powerful ritual, a reminder that despite their profound disagreements on law and policy, they are part of a single collegial institution. Then they get down to business. The Chief Justice begins the discussion for the first case on their docket. He summarizes the facts, the arguments, and then, crucially, he states his view and announces how he intends to vote. The floor then passes to the next justice in order of seniority. From the longest-serving associate justice down to the newest member of the court, each speaks without interruption. This is not a debate like the oral argument. It is a structured, formal declaration of positions. This tradition ensures that every justice, from the most powerful to the most junior, has an equal and uninterrupted opportunity to state their case to their colleagues. At the end of this solemn discussion, a tentative vote is taken. This is the straw poll. It's the first time the world outside that room has a potential winner and a loser. But this vote is not binding. It's not set in stone. It is merely the opening move in a complex intellectual chess match that will play out over the coming weeks and months. This is a critical point that most people miss. The vote at conference is just the beginning of the negotiation. And the next move is perhaps the most strategic of all, assigning the opinion. If the Chief Justice is in the majority in that initial vote, he has the power to decide which justice will write the official opinion of the court. This is an immense source of influence. Does he assign it to the justice whose legal reasoning is most aligned with his own, to create a strong, narrow precedent? Or does he assign it to the wavering justice in the majority, allowing them to write a more moderate opinion to ensure their vote doesn't flip? Does he assign it to himself to lend the full weight of his office to a landmark case? It's a calculated decision with ripple effects that will shape American law for generations. If the Chief Justice is in the minority, if he dissented from the initial vote, then that power falls to the most senior justice who was in the majority. They now become the strategic commander, deciding who will be the author of the law. The assigned justice, with the help of their brilliant, young law clerks, then begins the monumental task of drafting the majority opinion. This document is far more than a simple declaration of who won. It is the reason why they won. It lays out the legal analysis, the historical precedent, and the constitutional interpretation that justifies the court's decision. This document will be scrutinized by every law professor, judge, and lawyer in the country. It will become the law of the land. But while one justice is writing for the majority, other justices are busy writing for the other side. Any justice who disagreed with the outcome can write a dissenting opinion. A dissent is a powerful statement. It's a roadmap for future challenges. It speaks to a different vision of the law, often written with a fiery passion, in the hopes that a future Supreme Court will one day see the error of the majority's ways and overturn the decision. The famous dissents of history often become the majority opinions of tomorrow. And then there's a third path. A justice might agree with the outcome of the case, who won and who lost, but disagree with the reasoning used by the majority. In that case, they can write a concurring opinion. They concur with the judgment, but they want to offer a different legal path to get there. These concurrences can be just as important as the majority opinion, sometimes limiting its scope or suggesting alternative ways to think about the issue in the future. Once a first draft of the majority opinion is written, it's circulated to the other 8 justices. And this is where the real battle begins. This is not a polite academic exercise. It is a high-stakes negotiation for the heart and soul of the decision. The other justices in the majority will send back memos with suggestions, demanding changes to a sentence here, a footnote there. They might threaten to withdraw their vote and write their own concurrence if a certain line of reasoning isn't softened or strengthened. The goal of the opinion author is to craft an argument that can hold their fragile majority together. A 5-4 majority is a knife's edge. Losing just one vote means you lose the majority. Your opinion suddenly becomes a dissent, and the entire outcome of the case can flip. Imagine a master architect designing a skyscraper, but every one of her 4 key partners has a veto on every single beam and window. She has to persuade, cajole, and compromise to keep the project from collapsing. That is what it's like to write a majority opinion at the Supreme Court. A justice might join the majority but write a separate, narrow concurrence that effectively guts the main opinion of its power, creating a fractured, confusing precedent. Sometimes the negotiations are so intense and the disagreements so deep that the original majority falls apart completely. The justice originally assigned to write for the majority might find themselves writing a dissent instead. This has happened. The legal ground shifts beneath their feet, all within the confidential confines of the court. And while this secret, intense intellectual war is being waged through memos and draft opinions, what about the Supreme Court lawyer? The one who stood at the lectern all those months ago? They are in the dark. Completely. They receive no updates. There are no leaks from the court. It is one of the most leak-proof institutions on earth. They read legal blogs, they talk to other court watchers, they try to read the tea leaves from the questions that were asked at oral argument, but it's all just speculation. They and their clients whose lives or businesses hang in the balance are simply waiting for a puff of white smoke from the marble temple. They are adrift in a sea of uncertainty, knowing only that 9 of the most powerful legal minds in the country are debating their fate, rewriting the very rules of society, and that they will only find out the result at the exact same moment as the rest of the world.